Hi there, I'm James Dapachi, and this is Coffee and a Case Note. Team, today we are going to have a chat about an application for an interlocutory injunction, an immediate stop. Right, what are we talking about today? We have got a number of entities. We've got our plaintiffs, and we're going to define them loosely as plaintiffs because there are a fair few people involved, and we've got our defendants, and we're going to define them quite loosely because there are a number of defendants involved. And I should also say, today we're not being too surgical and precise. We're going to paint with broad brush strokes, so forgive any vagueness or any details that we gloss over. Now, what we have is plaintiffs coming to the court seeking this injunction, saying we want an injunction, we want an immediate stop. And the nature of this injunction that is being sought is they want to stop the defendants from making certain publications on their website. Now, what they say is that the defendants are improperly saying that they own or have licenses for the plaintiff's patents, right? The plaintiffs say we own these patents, and we want the court to stop the defendants from saying that they own them. It's a complex argument with a bit of background, so let me jump back in time for you. Our plaintiffs purchased a number of companies from the defendants and entities related to them. Those companies owned a number of patents. And what the plaintiffs say, in essence, is that as a result of these purchases, we came to own and control these patents, and so they are now ours. And so we can now come and prevent you, the defendants, from saying that you own them or that you hold the licenses. Now, what the defendants say, and again painting with very broad brushstrokes, is that over the course of a number of years, or at a certain point over the course of a number of years, and the evidence in relation to this is a little bit complicated, but in essence they say, look, there was this license agreement, and we, the defendants, enjoy a license that has been granted to us, and so we in fact do have the ability to control the patents. We can go out into the marketplace and say we hold the license. We can go out into the marketplace and say we control these patents, although we accept, and the defendants did accept this, that we don't own them. We merely enjoy a license. Well, what the court has to ask when there's an application for an immediate interlocutory injunction, if you excuse me a moment. Thank you very much. Oh, that looks fantastic. Wonderful. Thank you so much. Is that the court has to be satisfied that, it's lovely, that there is a serious question to be tried, and the court has to be satisfied that the balance of convenience and other discretionary issues favour the making of an injunction. And so if we boil down all the complexities, in essence what the court has to be satisfied of here is, was this license that the defendants say they have valid? Because if it is, what they're saying is fine on their website, and if it is not, what they're saying is misleading and deceptive conduct. And so the court has to say, look, is there a serious question to be argued here? Is there a genuine dispute about whether or not this license was validly granted? And the short point is the court says yes. There are a number of reasons for doing this, including some of the defendants seeking a license in respect of the powers that they now say they have in the years following their purported grant of license, if that makes sense, and a number of versions of this license deed, each of which is a bit inconsistent, and some of the defendants behaving in ways that would be consistent with not having the license. And so what the court says is, look, because it's an interlocutory injunction, we don't need to decide this right now. All we need to decide is there a serious argument about this? And the court says, yeah, look, there's enough evidence here for us to say there's something serious for us to discuss. The next question is the balance of convenience. Now, what the plaintiffs say is we are out in the marketplace with these patents. We need to be doing deals in relation to these patents, and the patents related to biometric sort of face identification, and serious companies like Apple are relevant. And so they're saying, look, we're out trying to do these deals, And it is really damaging us commercially to have the defendants saying that we don't have the right to do deals relating to these patents. And so the court considers the position, considers the relevant patents and a number of other patents that the defendants do own, and finds that the balance of convenience does favour an injunction. And so the court does make the orders stopping the defendants from having those publications on their website. Now, an interesting subpoint on that serious question to be tried that I should have mentioned earlier, and I apologise for leaving till now, is the question about seriousness of the question is about, is the licence valid? Well, on that point the court finds it seriously arguable, but then the court said, look, even if the licence is valid, the liquidator of the relevant company has disclaimed that licence as an unprofitable contract pursuant to Section 568 of the Corporations Act. And there's a serious question, even if the licence is valid, as to whether that disclaimer is effective. And so, as you can imagine, the court has little difficulty in saying, look, there are some genuine proper arguments here. So the injunction is granted and our defendants are restrained from saying those things anymore. I hope that discussion assisted you, and I look forward to joining you again soon for another coffee and another case note. Cheers.